Yeah, it is Friday morning. Yeah, so I think it is important to kick off with thank you for joining us on this session. It is interestingly just called Decolonization, and I'm sure that leaves even you, the panelists, wondering decolonization of what, right? So I think it's safe to assume we're thinking about international economic law as a field here. So today we have three excellent panelists who are waiting for José to join us. But to my right, we have Matheus, Gobbato, and to my right, we have here Enrique, who is from one of our hosts as well. So thank you very much for the work you have done putting this conference together. The plan here is easy. It's for us to go through the conversation, right? That you've all been kind enough to share with me. What are potential areas you're likely to touch on? And I think they offer a very interesting overlap.
José Manuel.
Yeah.
Welcome.
You can join us. Yeah.
No, we just started.
Morning, José. Oh, good morning. Okay. So José has just joined us now, and we're happy you're here. The good thing is we are just kicking off, and I was just saying to everyone here that we have what looks like a very interesting set of remarks that you all plan to offer. We have 3 panelists, so it means we have some time to go as we've pre-arranged, and maybe without more, if we can kick off with Matheus, right? In your own first few minutes with your remarks on this. Thank you very much.
Thank you so much. Morning, thanks to the audience for attending. And so I'm here to talk about this project of history of international economic law I'm working on. And it's about the international economic legal scholarship of this Brazilian internationalist called Celso Albuquerque Melo, who lived from 1937 to 2005. And he published very prolifically on many issues of international law. And but I'm focusing specifically on his work on international economic law from the 1970s to the 1990s. I intend in this project to use his work on international economic law to tell a broader story of the discipline, a story that goes from the once hopeful moment of the perspective of the completion of the decolonization project. So not only the political decolonization, but the economic decolonization. But as I can tell from analyzing his work, there was this move from hope to concern when the debt problem became debt crisis, and then in the 90s a moment of disenchantment, a moment of hopelessness as the neoliberal project took over and sort of say kill the international development law project. But before I say that, I want to talk about something. Why is it important to say that it's a project about the history of international economic law and not about international economic law? Because as I have seen from this conference, crisis reveal the fragility of the normative and institutional structure that we are debating here, and so requires us to give this step back away from the technical normative positivist debate on specific rules and that we have seen so far in this conference, and try to understand more like that international economic law is a stage of confrontation from different world-making projects. So on the one hand, we have development and the perspective of radical reform of international economic institutions, economic decolonization, and international economic justice, and so on. And on the other hand, we have, as I can gather from the work of Celso Melo, this Brazilian internationalist, but also of Bhupinder Chimney, that international economic law can be seen as a backlash against these demands from the so-called third world that became somewhat sort of too strident, and then the international economic law via this vertical move, supranational move of dethroning politics, encasing the market, protecting the market, and strengthening supranational institutions, try to contain this supposed threat of posed by not only the organized labor movement, social democracy, but especially decolonization and liberation from the third world. So I can continuing by talking about the relationship, theoretical aspect of the relationship between international economic law, this neoliberal counter-revolution that I may call this way, and global imperialism, but I'll leave it that way just to start the conversation, and I'm eager to hear my colleagues. Thank you.
Thank you very much, Matheus, for your initial reflections. You know, I think it's interesting that, you know, you chat what is similar to what, you know, one of the keynotes, right, yesterday noted about this moment, you know, of hopeful agenda for what the world could be. And then, you know, there's then the moment of reflection, right, where you think it's not gone that way. And so thank you for kicking us off on that. We'll turn to you, Enrique, for your own initial reflection. I know you've written a lot on these issues, again, specifically from the investment law perspective, you know, thinking about its coloniality and all what within that. So over to you for your initial remarks.
Thank you so much. And thank you everyone that joined us here this Friday morning and the last day of the conference. So my reflection, or what I want to share in this panel, is part of my research, and it's about to analyze whether international investment law is a form of colonialism that facilitates what I call as systemic violence. Now, this analysis is not new in the critical studies. However, it seems that for practitioners and orthodox approaches to international investment law, this approach of colonialism seems to be wrong and not properly based on factual information. Now, the question that I'm trying to think is whether is it still important to think about investment law from the perspective of colonialism in 2023? And my answer is yes. Now, in this research, and of course I will talk about this in more detail, first I tried to trace the colonial past of international investment law, how this was a post-war system that aim at maintaining the political, legal, and economic control of former colonies. And then I moved to argue how, based on what Enrique mentions as the power of, or the colonial turn in modernity that allowed Europeans to have this epistemical superiority. So then international investment law was, or became in a sort of, or transforming a sort of encrypted system. And that encrypted system created an elite of people, mainly arbitrators, that are to, or that are entitled to decrypt this whole system. And perhaps in the second part, I will talk in more detail about this. Then what I look at is whether this system that has a colonial past that is encrypted, that creates this elite of arbitrators that are all white men from the Western world, and I have here the data to share with you, whether this system is transforming in a mechanism that creates systemic violence against developing world. And my answer is yes. Why is that? Because, and I will share with you in more detail later, the amount of money that the developing countries are forced to pay are so high that it creates regulatory shield, and countries are avoiding, and here in Colombia is happening, are avoiding to regulate, or here in Colombia to represent victims as to avoid being sued by foreign investors. Finally, I move to the ongoing changes that the system is happening. So you could hear about exit, changing, UNCITRAL there's a working group to change. We have new treaties like the Canada-European Trade Agreement that apparently are the solution to this. And now what I argue is, using Niklas Luhmann, that this is just an autopoietic turn, in the sense that just the system is trying to maintain alive itself, but is not changing profoundly. So we'll leave it here and we could talk in more detail about that research.
Okay. So, I mean, thank you very much, Enrique. So I hear you say that there are continuities, right, of colonialism in the way we think about international investment law, right? I'm sure you know about it, but you know, there's a book that David Schneiderman, right, recently published, you know, which seeks to track some of this as well. And there's been someone who also wrote about the Caribbean context of this as well, from a third world approaches to international law perspective that I can share with you. But that all sets up nicely to come to you, José. You know, I think it's interesting because from Matheus and from you, we've used, you know, the context of decolonize, right? Without, as though we all have a very set meaning of what it is that we're talking about. So I know in your own, you know, poses for this panel, you've indicated, you know, you might problematize a little bit what it is to decolonize knowledge, for example, and then if you want to relate it to international economic law in particular. So in your own first 7 minutes, I wonder which of those you really want to pick up at this time.
Thank you, Lizzie. I am very happy to be here in the company of my colleagues in the panel, and I'd like to greet Professor James Tugogati and also my friend Miguel Rábago. The title of my paper is Decolonizing International Economic Law. It's mainly based on this decolonial theory, but has a strong component of 12, mainly Anthony Angie. So my paper has 4 parts. The first is, what does it mean decolonizing knowledge? The second, rewriting the history of international economic law as decolonization. The third, the Eurocentric history of IEL. And 4, the colonial history of IEL. So in my first part, I will speak of what can be mean decolonizing knowledge, and in particular, pointing to decolonizing this discipline of IEL. In this paper, decolonizing knowledge means subjecting the knowledge to decolonial thinking. And what does mean, what it is, decolonial thinking? There are a number of authors, not only in Latin America, but all over the world, that have different understandings of decoloniality, or what does mean decolonizing knowledge. But for me, yes, decolonial thinking can be understood as a kind of dialectical process that includes a thesis, an antithesis, and a synthesis. This is the schematically understood Hegel's dialectics, but is to give an idea of what kind of thinking is this. So it has 3 moments or movements, in which the first one is criticizing Eurocentric knowledge. The second one is retrieving or recognizing the Southern knowledge as valid, as truthful. And the third one is facilitating or creating the conditions for a dialogue between those 2 knowledges, the Eurocentric one and the Southern or third world knowledge, or the colonized, or the knowledge of the colonized. And I took this way of understanding decolonial thinking mainly to the field of history. You know that for the last 20 years or 30 years, there has been in the field of international law this turn to history, created by Twale and also by European scholars. So history has become a discourse that operates as a kind of critical discourse. So I use history to decolonize knowledge. So if you want to criticize or decolonize the history of a discipline, you would need in this approach to first to critique the history of the discipline, the history that appears as the universal history, the only history, or the only known history. Then to recognize or to create or to write another history which has to do with the history of this discipline in the history of colonialism, at least since the 15th and 16th century. And then establishing a dialogue between these two histories. Here, I would like to mention Chimamanda Ngozi's idea of the dangers of the only history or the single history. Yes, that history can be true, but is always incomplete, is partial, and can create a kind of schematic understanding of the subject. Yes. And also would like to mention Chinua Achebe's idea of the balance of stories. Yes, you need to balance the single history with another history. And what I am going to do in this paper is to rewrite the history of international economic law on the basis of tracing an Eurocentric history to put a parallel history of international economic law in the context of colonialism, and to try to establish a dialogue between the two. Should I stop here or go to the second?
I think that's a good spot to pause, right?
Yes.
For this one. But I think the interesting thing where you've taken us, invoking critical literature, right, to think through international law, which I think Joy Slaughter, a couple of other folks are thinking about as well. It's very interesting, especially going to Chimamanda and Chinua Achebe, late Chinua Achebe. But I think you also set us nicely to come back to you, Matheus, right? Because in there we do see there's a very strong strand, right, of theoretical thinking, the subaltern's capacity to produce knowledge, and how we assess that in mainstream international economic law. So you started hinting, right, about the next dimension you wanted to go to your presentation. So you have the next 5 minutes now to do that.
Thank you, Olabisi. So as I said, the perspective I'm adopting in this paper regards international economic law as a counter movement, as a backlash against the attempts of the global south or third world to democratize international legal order and decolonize international legal economy. And then the neoliberal ideology instrumentalized international economic law to this purpose against this reformist, solidarist view that used to be alive, let's say, in the 1970s and 1980s. And Celso Mello, this Brazilian author that I'm analyzing, he really embraced this international economic, the idea of international economic law as international law of development or international development law. He conceived, therefore, international law as an instrument in the fight against underdevelopment. He reinforced the necessity of differentiating, not ascribing to universalist accounts of international law. And also, specifically, he saw international economic law as the stage of confrontation, not only between the East and the West in the 1970s, but it should notice that it was a struggle between not only the North and the South, but between the rich and the poor. And not only that, between nationalism and internationalism, because one of the ways that international economic law managed to back off this third world sovereignty and development demands was by pulverizing or moving sovereignty towards supranational institutions. And here we have the biggest examples we have are the EU and also the WTO. The WTO as an example, the greatest example of this crystallization of a neoliberal post end of history single thinking, to use the term that you just said. Like it became after the 90s, it became the only available project within the international economic law community, and the notion of international economic law as development, as an instrument for development and for third world sovereignty, as a shield against multinational corporations, the interest of transnational capitalist class, to use a concept, another concept by Professor Bhupinder Chini. So I divided my paper in these 3 decades. So in the 1970s, Professor Mello used to talk about a lot about nationalization in favor of expropriatory measures, about the internationalization and multilateralization of development assistance, in favor of domestic control of international contracts, in favor of regulatory space for developing countries. And the problem is that Mello published only in Portuguese, and that made him very isolated from the international legal community and also from Latin America. So one of the purposes of this paper is try to establish bridges and dialogues of Mello with other, especially Latin American legal scholars that at the time were writing about the same issues, such as Eduardo Novoa Monreal in Chile, Jorge Castaneda in Mexico, Héctor Gross-Piel, Jiménez de Arechaga, and others, and also making a dialogue of Mello with trail scholars from either from the first generation, so Mohamed Bejawi, but also trying to understand how this idea of international economic law as development and as third world sovereignty fits within the trail project. And by doing that, I also want to understand more deeply what is the role of Brazil in Latin America within the third world, and Brazil within the third world, because Celso Mello was one of the founding fathers of international economic law discipline in Brazil. He systematized knowledge, and so for me it's important to situate and to place him within this greater legal tradition of critical thinking within international law. And I can continue, but I'll stop here.
Okay, thank you. There'll be a third round, right? To do that. And I think I must thank you all for respecting time and be willing to share equally. I think it's fascinating because, I mean, you will probably know Nicolas Perron is doing some of this type of work, right? Trying to bring into conversation some of those authors that, you know, that because of language, really have not been able to be in mainstream. And you can think about it there are parallels in the African context, right? There's a man who died some years ago, Adeyemi Adedeji, you know, who wrote a lot, an economist, about how to think about economic integration in ECOWAS and in West Africa. And so it sets up nicely to come back to you, Enrique, to carry on with your own intervention now.
Thank you. So in the following 5 minutes, I'll try to elaborate on my arguments. So still today, there are 2 stories and histories of international investment law. One that I'm always reminded by my colleagues is that thanks to international investment law, we moved from gun-ho diplomacy to technical judicial bodies to resolve swiftly and independently claims of foreign investors. However, there is a counter history as presented by Kate Miles and other authors. The argument behind here is that international investment law is the result of economic, political interest of former colonial centers to maintain legal and political control over former colonial countries in order to protect their economic interests and their interests of their companies. I include myself to focus on the second history and story. I argue that international investment law is a north-south system that follows a logic of epistemological superiority of the north to the south. Here I base my arguments on Enrique Dussel, and also I argue that international investment law, and I use the term by Sunja Payuha, is based on epistemic superiority that grants the West what is known as the normative monopoly in the creation and development of public international rules, and specifically international investment law. As mentioned by Marty Koskaniemi, international law today offers a wide variety of specialist vocabularies and institutions in which we engage in the legal practice. However, as David Kennedy mentioned, we commit to this language without reflecting on their effects in the world of outcomes. Why I'm saying this? Because from this colonial perspective, I'm moving to analyze in more detail what is international investment law. And for doing that, I focus on the discourse and I try to analyze its words. Now, the development of international investment law has characterized for using terms and clauses that are specialized and general. Specialized in the sense that uses terms such as most favored nation, indirect expropriation, or umbrella clause, and general in the sense that the clauses are broad enough to give room for expansive interpretation by arbitrators. I argue that this has created an elite of initiated that possess the keys of knowledge to interpret this discourse. And here I use Foucault. The existence of the initiated is based on appropriation and enclosure of production of knowledge that creates Manichaean division between legitimate interpreters, probably most of us that are here, with the right to interpret and speak, and others that are illegitimate interpreters, insiders, outsiders. In this form, insiders transform themselves in a class of specialists that are legitimate to speak and are legitimate to encrypt and decrypt the international investment discourse. I categorize those legitimate people in two types. One, observer interpreters, maybe academics like us, and the other one, decision-making interpreters, arbitrators that we have many here. That small group of individuals that I call as decision-making interpreters are the legitimate interpreters with the key to decrypt that knowledge. And why is this important? Because we have to look at between 1966 and 2022, according to the last report of Exit, the majority of arbitrators and conciliators, these ones that have the power of knowledge, are from the West. Let me give you just a data, and is for 2022, 76% were men from the Western world, white, old men. I leave it here and continue in the next round with the next argument.
Okay, so I think what I like is you guys are doing a great job leaving teasers out there that I hope, you know, that I hope we can engage with in the conversation. But, you know, I can't help also, you know, your evocation of the outsider, insider. I'm sure you probably know, you know, Anthea, Roberts, and St. John's outsider and insider analysis, and to what extent that features or maps onto your own thinking will be interesting to explore. But then I move on to you now, José, to then carry on, right, with I'm sure the Eurocentricity of international economic law and how you see this working out.
What I said in the first part is that I will try to decolonize IEL through rewriting the history of IEL. So I will, to do this, I will use this scheme of critique, recognition, and dialogue. And the first part is the critique, and the critique the critique to international economic law has to do with this characterization as Eurocentric. It's not only that Eurocentrism is key in international economic law, but that international economic law is Eurocentric. And what does mean Eurocentrism? There are a number of understandings of Eurocentrism, but here I understand Eurocentrism as a perspective that emerges from the history of the West, a perspective that marginalizes the colonized world or the third world or the global South, and third, a perspective that sets the interest of the imperial West as its main criteria, the guiding criteria. In this sense, the history of international economic law deals mainly with events that happens in the West. It excludes events or doesn't have to do or only in a minimal way with the history of the global South. And third, that there is an implicit or not declared key guiding criteria, which is that of serving the interest of the West, of the Western empires and colonial companies, with a very specific, particular or general objective, that of securing the colonial accumulation of capital against the interest of the colonized people. But we need to write another history of IEL, a history that can start with the conquest of America. Modern colonialism is not marginal to international economic law. On the contrary, is central to it. And here I am drawing from Anthony Angi's idea that public international law has colonial origins in the conquest of America. And this criteria is also valid to international economic law. So the international instruments that were adopted at the time of the conquest of America, such as the Papal Bull Inter Caetera and the treaties of Tordesillas and Zaragoza that divided non-European continents and seas between Spain and Portugal and secured the sovereignty on them. At the same time, these treaties transform the continents and the seas into places of exploitation of commodities like gold, silver, emeralds, pearls, etc. They transform at the same time the vast extensions of the territory of the continents into private property. They transform a part of the inhabitants of the Americas and Africa into slaves, and in this way into chattel, commodities, or the property of traffickers and landlords or encomenderos. These treaties secured the obtention, they got a surplus value out of the work of slaves and out of the work of human beings subjected to forced labor. And they secured the seas as spaces or routes for the transportation of commodities, slaves, colonizers, and troops. And all of these economic processes were made possible by a whole era of extreme violence: torture, rape, mutilation, murder, and genocide. And economics and violence combined constitute the colonial accumulation of capital. So the history of modern international law cannot be separated from the history of international economic law, and vice versa. The history of modern international economic law is inextricable from the history of modern international law. The modern history of IEL starts with the colonial accumulation of capital. And this colonial history of international economic law seeks to put into evidence the role that IEL played in legitimizing the violence and the looting of colonization, aimed mainly to secure the colonial accumulation of capital. And second, it seeks to use IEL as a tool for the defense of the peoples of the global South and securing their economic prosperity.
Thank you very much, José. Jane, those are interesting points and facts that are relevant not just historically but contemporarily as well. One thing though I want to leave with you, and then I would have to exercise some kind of moderator's privilege here, hopefully in your interests, that you will agree with me, is, I wonder whether you later on in the paper, right, I'm not too sure there'll be time for that now, find that there are accounts you can put on the table, right, of knowledge produced by the Global South, right? You would agree that we are producing knowledge, right? So to the extent that we are producing knowledge, it is important to mainstream those, right? As well as part of the narrative to pluralize, right? What is the Eurocentricity in international economic law? But again, I'm just putting out there as a thought. So this is what I propose. This is 9:44. We started 5 minutes later than we should have. And so I think it's fair, if you agree with us, we go to 10:05, just to keep it fair. But I know you like questions, right? Rather than speak for another 2 rounds, which takes us to about 6 minutes left. So if you don't mind, I want to open it up to Q&A, and then hopefully we can maximize the next 17 minutes for that. And so it's open. I hope there are people who want to comment on this conversation with say Matheus and Enrique. Yes, please.
I'm a player, so from Brazil, so I'm really the discussion much. So I was just wondering, how can we use this theories and colonization discourse or approach to address current developments? So talking about investment and talking about Brazil, we have Brazil understand the IT, but now we have a completely different approach to investment. And we have South Africa and also similar models or similar agreements focusing on investment facilitation and governance. So how can we fit this approach? And this is this new movement that I think is investment law in this emerging economy is leading in the picture, given the backlash against ISDF investment.
Thank you very much. So we'll take that as a general question, but we'll come back after. We can take one more in this initial round. I think James, you had.
Yeah, so this is a great panel. Just 2 very quick moments. One is just to plant an idea in all of you, which is that I hope this conversation does not end with this panel, and that you're thinking about how you carry forward this conversation in a way that we can learn from all the work that you guys are doing. Secondly, and this is something I'm struggling with myself. I mean, I found everything you say very compelling, and so I'll direct this to Enrique, but all of you can feel free to answer. I was very struck that you invoked Foucault, especially given that Manuel was sort of persuading us, and maybe this is the spirit of the conversation. I don't know. And the reason I ask is because in a very related project here, I'm struggling with using Bourdieu for the very exact reasons that you're using Foucault. And the reason for me Bourdieu is very limited, and I'm doing a revise and resubmit, is because he does not address questions of race with regard to distinction or any of his work. It doesn't go into questions of race. And for me, looking at ICJ counsel and advocates, I'm really focusing, like you're focusing on ISDS arbitrators, on the lack of people from the global South and women. And Bourdieu doesn't help me there. So I'm sort of just putting this out there. Maybe you guys have thought about this more than I have, about how you engage in this kind of a dialogue with these epistemic frames that themselves have their own limits, although they also have their really great potential, like you were saying about the whole knowledge industry and people's authority. So that's my.
Thank you very much. So we have two questions. I think you can all who wants to go. Maybe we start with the one that is directed.
So, well, thank you. Perhaps I just would like to say a few things. I mean, first, I'd say that investment law has colonial past, then that it has encrypted discourse, and then I argue that investment law serves as a vehicle of systemic violence. For this purpose, I draw on Frantz Fanon, mainly on the wretch of the earth and black-skinned white mask. And what I use this just to give you some data is from 1966 to 2022, exit cases, 31% of those awards were upheld for the investors, and 9% were agreements between the parties in which, of course, the state ended up paying money. Now, and usually, if you look at the data, the claims of investors, usually the average is 1.16 billion US dollars. And then usually the amount of money that states are ordered to pay is $437.5 million. Now, why I'm saying this, and just to conclude here, and perhaps trying to address two questions. So I say the international investment law causes systemic violence as it creates and maintains unbalanced legal and economic and political conditions that have direct impact on the social, psychological, and physical integrities of citizens of the third world, restraining, among others, opportunities of social improvement and protection of the environment and culture. Now, having said this, what I think, and especially for Professor Jete, is the following. I'm acting as a bricklayer in the sense that I'm trying to bring different theories that could work to present these limitations of the system in terms of cultural, race, and gender. Now, I mainly draw on the archaeology of knowledge in the sense of trying to bring or highlight that usually there's some people that have the monopoly of knowledge. And investment law, we have the monopoly of knowledge in white Western men. Now, as I was saying here, then in my research, then I moved to mainly use third world thinkers, Enrique Dussel, and of course, mainly Frantz Fanon, Luis Gordon, or Latin Americans like Oscar Guardiola Rivera as well. Now, and why I moved to, you may say, well, perhaps it's wrong to combine theories, but I guess, is it wrong to combine theories, or perhaps theories could serve to show injustices and balances, and perhaps to give us the opportunity to rethink. So I moved to this second part of the argument. And moving back to the first question, I think when, for instance, Frantz Fanon, he talks about this kind of systemic violence, and he has been wrongfully read in terms of promoting armed violence. And he wrote in 1960s, right, during the Algerian decolonization process. And when I think, well, how is it useful to bring Fanon to ISDS in 2023, right? I think it's very useful because it gives us the lenses to raise red flags around the system, how the system, and this is part of my conclusion, how the system maintains control from in the past between 2000 and 2011 from Western countries, and now from corporations, in how countries in developing countries act, how we regulate, what are the laws, right? For instance, can we issue laws against or promoting non-smoking policies? Well, perhaps not, because Philip Morris will sue, right? Or can we protect paramos like here in Colombia? Well, perhaps not, because we will get sued. And then for millions of dollars that for poor countries like us represent a very important amount of money. And then at the end, the most weak parts of the population will be affected. So I don't know if I answered questions or not, but if I got more complicated. Thank you.
Thanks. So you both have the time. That's what it's interesting, because when we're planning for the panel, I assumed we had 1 hour, right? And I've still just assumed we had 1 hour, right? But it's 1.5 hours we have, right? So so again, pardon, thanks for bringing that to my attention again. So you have some more time to be able to come back, hopefully after the Q&A. But I wonder what your reflections are on the question that seems to be for everyone.
I can jump in. Yes. Thanks for the question. Thank you, Anna. I guess that touches upon one of the greatest challenges of our intellectual and critical endeavor, which is, to my understanding, the international legal community, and especially the international economic legal community, remains encased from reconciling itself with history. And I want to say that it's important that international lawyers acknowledge history, not just as pertaining to the past, but to the present. But it's important to see international law, how international law updates domination through different forms. And so I guess this is the greatest challenge we face. And addressing Anna's question specifically, I guess so. Bringing history to the forefront is one of the ways that we can reinterpret current challenges. I guess this is very important. For example, yesterday we heard that to face current climate change problems, we shouldn't make it a north-south issue. I strongly disagree with that. I think we should strengthen differentiation and common but differentiated responsibilities, the differentiation aspect of it. That's a whole, that's part of one example of the challenges that we face. And regarding the new challenges of investment, Celso Melo, by the end of his life, he was very critical to the Washington Consensus, the Uruguayan Round Consensus. And then he said that we are arriving at a very dangerous unipolar global imperialist world. And then he said that he was talking about Brazil. Brazil should look for South partners to do its kind. So he was hinting at South-South cooperation, and he was hinting at what we are seeing now with the BRICS. And I guess one of the ways that, to my understanding, this conference is very much focused on one specific regulatory project of international economic order, which is Eurocentric, to use my colleague Manuel. And then I guess developing countries could benefit from having a multipolar world, trying to negotiate better positions and trying to bring back neutrality and a new way to get better regulatory frameworks that adjust to their development needs. Thank you.
Okay. Thank you very much. José, do you want to come in?
Mainly to your question, Anna. Yes. Well, I think Tuel and a number of people are working for the last 30 years on decolonizing international law. And then within international law, we can go for international economic law. And then within international economic law, we can work on the decolonization of international investment law. And by chance, in preparing my paper for today, I bumped into a book about international investment law, and it says the following: it is common to find that the history of investment law starts in the 1990s with the proliferation of BITs after the collapse of the Soviet Union, the protagonists or actors being states, corporations, international organizations, arbitration institutions, and NGOs. So what kind of history can be constructed on the basis of this, starting in the 1990s and in the question of, with the question of the collapse of the communist war? It's very short term understanding and very short in terms of geography. So there is an opportunity to write another history, the history of investment law in the history of colonialism. And I think from the very beginning, from the history of America, the conquest of America.
Thank you very much. I mean, it's interesting. I'm not sure whether any of the questions we'll take will touch on this, but if my mathematics is correct, next year will be, you know, NIA of 50 years, right? Potentially. Is it 50 or 30? Like, poor mathematics, but there's a moment to reflect, right? 50. Thank you very much, right, on that. And I think, you know, speaking about all of the decolonization of IEL, is probably so many ways we can think about this, and maybe taking on James's invitation, we can talk about how to think more broadly of carrying on this conversation. But yes, we have more time for the second round of questions. So how do we go now? With the lady, exactly. Thank you very much for being gentle, and then we can take all the others. Thank you.
Talking about subjects of international law, and as a conclusion of this session, let's talk about decolonization means Eurocentrism. Should the multinational companies be a subject of international law? Yes, no, why, how?
I couldn't understand completely your question.
If the multinational companies should be part of the international law as a subject.
Okay.
You get it now? Okay, so we'll come back to that. We'll let it sit. We'll go, yes, you can go on there.
My question is more methodological. I think that's across whoever. Okay. My question relates mostly to scope and scale. So what we are hearing, especially from Enrique and Manuel, is an intellectual history, right? Especially Enrique. And it is a turn from an epochal or a big idea to an intellectual history. And there I want to push a bit on that question of scale and scope, like what is the scope that we are discussing? What is the context, the specific context of these people that we have? And the scale, how much leverage do these actors have on reality? Like, if treaties are unequal, like, you know, even if you put, you know, the most convinced person on the panel, probably they won't do anything. And the other question is about, we are negotiating Eurocentrism, Eurocentrism. The question is, there is a strand of literature, especially in Latin America, that discusses Eurocentrism through the idea of hybridization, the mestizo, international law, how this kind of the merging of ideas, you know, of Latin America. I want to ask whether this is valid to you or international law is beyond. You cannot
Redemption.
It's colonial.
Okay, thank you very much. Yes, and then.
Just following that question, I think it's important that when we're talking about the decolonization, of course, decolonization in South America, Africa, South Asia, but also all the other things that enter into this discussion, including the intersectionalism, for instance, feminism, right? So how do you think you integrate all these views in order to actually make this change in the concept?
Okay, thank you. So we have 3 questions there. It's only 10:01. I think we have time, right, to sort of answer this, and then we take your 2 questions. Yeah, okay, thank you very much. Do you want to, how do you want to go? Do you want to start first? Yes, see, Manuel.
Yes, I would like to start by answering your first question, and then to link it with your question. You ask about the time framework. If we are to create or to write a long-term history or a short-time history, I think we can write both, but there is a necessity or a convenience to write also a long-term history, a history that deals with the whole history of modernity, understood as modernity coloniality. Yes, modernity as emancipation and coloniality as the opposite of emancipation, violence, subordination, and so on. So the structure, the economic, the political structure of the world today has to do or has the origins at the 15th and 16th century with the colonization of Africa, America, and Asia. So we need that kind of history. And that history was already written in relation to international law by Anthony Angie. I know people within 12 that they reject the idea of a long history. Yes, but there are a number of people who create methodologically and substantially in the possibility of a long-term history. And within that long-term history, we can think of multinational corporations as a kind of children of colonial companies. Yes, the Welser Bank in Venezuela, the British, Dutch, French, Danish, etc., East India companies. Yes, and they, in history and also in the theory of Grotius, they were sovereigns. They were as capable of governing a land, a territory, of having an army, of having authority on the places that they were as sovereign as the kings and as the emperor. So I don't have a doubt about colonial companies as subjects of international law and international economic law. Moving to multinational companies today, they are still colonial companies, but in the contemporary framework, the thing is more complex. I think in some circumstances they are sovereigns, but in others not so much. But yes, they need to be thought and put into law as subjects of international law, mainly to put on them responsibilities, not rights, but responsibilities. For instance, in human rights matters. Yes, and the last question about methodology. Yes, mestizo international law, hybridation, has to do with my understanding of decolonial thinking, because it has to do with these three parts. No? The critique of Eurocentrism, the recognition of a colonial history, and a dialogue between the two. The dialogue is that hybridation, is that mestizo thing. No? The history, the Eurocentric history is not false in most of the cases, but it's only a part of the history. So we need to establish a dialogue with the other history and make a more complex history. Both histories can contradict each other and can enrich each other.
Okay, thank you very much. So do you want to come in on any of the questions? Should multinational corporations be subject of international law?
I guess I agree with Manuel. It's a very complex topic, and I would refer to the 1970s. There were alongside the new international economic order, there was this very important document, which was the Charter on Economic Rights and Duties of States. And then I would like to stress the duties part of it, because I guess it's the most controversial. And I would say that international corporations could be understood as subject of international law, as long as it was to ascribe to them duties and responsibility and accountability and the regulation of their conduct, because it is very dangerous to equate like the public interest of a state to the commercial interest of a company. And then My answer is that I don't have an answer for this in this 1 minute. And I would like to touch on the aspect of the Mestizo international law as well, because as I was thinking about this paper and Celso Melo, this Brazilian internationalist, I was thinking about because the importance of Brazil as a semi-peripheral country, in the words of Arnold Lorca. And I guess that's really important to think about reform, because a semi-peripheral country has a privileged role of being able to propose reforms and leveraging reforms in the G20, and now Brazil with President Lula has been filling this void and vacuum left by the other president, and the perspective. There's room to be a little bit optimistic about the perspective of being able to reform using that power that a semi-peripheral country has. Of course, we're talking about reforms and not our desired revolutions in terms of accounting for nature, accounting for women's rights and things like this. This is it.
Okay, thank you.
Thank you. Well, first, Sophia, well, this is a very complex question. So first, I will take that from ongoing discussions in Black Letter Public International Law, right? So we have Rosalind Higgins, who is saying, well, we need to move from talking about international legal personality and subjects of international law to talk about participants of international law, right? So she's herself criticizing this construction of subjects of international law, right? Now, on the other hand, one moves and look, what is to be a subject of public international law? So in Orthodox learning, we say, well, are those that have international legal personality? What is to have that? Rights, duties, the opportunity to enforce its rights and to be international responsible. Now, if we think about corporation, what happens with them is complicated, right? Because, for instance, when they are on the category of foreign investors, they are protected by international treaties. They could bring claims directly against the states. And there are also, opportunities in which they even could argue violations of human rights. So this is so complicated, and usually when you talk about corporations, you say that when they act as foreign investors, they have what is called limited international legal personality. So this is the kind of theories that people that do international law try to create to come out with an answer. Now, what is problematic to say, yes, they have international legal personality. The problem is that if that is the case, they could perhaps expand their scope to bring actions against the state, right? On the other hand, you could say, well, that's the reality. For instance, WTO, we think that WTO is about the states, but who are behind the states? For instance, claims against Colombia by the EU was Diageo pressing the EU to bring a claim against the state. You could also say, well, they're already having the opportunity to sue states, but they're not obliged under international law, as José Manuel says. So what about if this idea behind the Business and Human Rights Treaty that is being negotiated of imposing direct obligations on companies could happen, right? So I know I don't have an answer. I have more questions, but that's a point. Now, I will conclude that there are two Colombians. One is Santiago Castro Gomez that works on decolonial theory, and Oscar Guardiola Rivera that's work back in the UK. They talk about the era of global centrism, in which we need to stop thinking about West and the other, and more about corporations using the whole world for the benefit. But in this construction, the third world is still being the most affected. And how it works that is that they use their leverage to make law in Western countries to impose the terms in international treaties, or for instance, to bring claims before the WTO. And well, at the same time, using the same power in developing countries to sign BITs or free trade agreement, right? So I really like this concept by these two thinkers about global centrism, right? So I will say that. And then I just wanted to say something that Matheus says, and is companies represent millions of dollars, while countries represent millions of people. Do you want to bring them together? Perhaps we're moving from the rule of law to a rule of the market. Who knows? Now, very interesting question about the scope. So I will jump. I agree with everything that has been mentioned. Now, in my work, I use genealogy. Every time that I use this, usually people come to me and say, "That's not a methodology, right?" The same time when I say that international investment law, I remember this in Chile. I said international investment law is colonial, and then a super Chilean professor came and said, "You are wrong because you haven't read my book. This is not colonial," right? So I'm used to that, and actually here in Colombia, I'm called the loquito del colonialismo, which is the crazy guy that, or the arbitrators, Colombian famous arbitrators, always like, yes, this is the poor guy that always talks about colonialism. Just let him be, right? Like patronizing me, right? Like, oh, poor guy. He's the funny, cute guy, right? So because he's the one that goes to arbitration conferences to talk about colonialism, right? So, but just to say this, why I'm telling this, because I guess the scope could be short or long, but also, for instance, Liliana Obregón talks about mestizo international law. I don't know if mestizo international law is a form to using fun, and I love and respect Liliana, she's my friend, but and if we have black skins and want to turn white, right? So we're trying to find a history that shows how we have impacted, and we're finding every single corner. We talk about the Institute of American International Law. We try to talk about the Drago Doctrine, the Calvo Doctrine, well, maybe we're the Calvo's Doctrine, the old doctrines, right? But I don't know. I don't know if we could. I'm not really into trying to talk about mestization of international law, investment law. I'm just trying to show how international investment law is far apart from us. So I'm taking a different quote from Liliana Obregón. Finally, Liliana, just a teaser, and is that there is the Oxford Handbook on Feminist and International Law. So René Urueña, Lina Cespedes, and myself, we're writing a chapter on the international investment law and its impacts on gender. So I invite you to look at that chapter.
Okay, thank you very much. So I think as you all gave your responses, two things came to mind that I think would be interesting to put out even for the audience, and then I'll come to the three questions. We're not ending, we'll take you all. So there's a book coming out in October 2023 by Umut Ozu. He's been working on this project for a while, Completing Humanity, the International Law of Decolonization, 1960-82. And I know he engages with the NIEO. And you all probably also know Sundia Pahuja is looking at international law and corporations now. So I probably want to keep an eye on. But yeah, next to the questions now. So how many do we have, just so that I can, so we take it all, right? You've been on the queue for a while. You defer to her, okay. All right, so you can start and then we go. Right. Oh, yes, please.
Okay. So thank you very much for what I kind of this relates to the regional developments of human rights in Latin America, which seem to be, they're very fascinating with Europe, that it seems that there actually Latin American countries have achieved quite a lot in terms of defining their own types of rules and the Pachamama development. So I was wondering, I have two questions linked to that. My first question is, do you have an explanation why similar development is not currently happening in the area of international economic law? And then the second question would be also Pachamama and the nature's rights and the human right to a healthy environment have a direct implication, of course, also on international economic law. Do you see perhaps a change coming from this other area of law that affects the way how international economic law is being applied in Latin America?
Thank you very much. He's been on the queue, and then I'll come to you, Suresh, and then I'll come to you. Yes.
Thank you.
Actually, lady already asked my question in her first question. Just let me contextualize that question. My question is much more pragmatic and solution-oriented one. I mean, yesterday I saw one book which was recently written by a couple of scholars at the university here in Spanish. I heard that it's the first book on the ISDS, on the investment law, written in Spanish. So it was quite a shock for me, because Latin America is the homeland for the investment disputes, but the first book is coming in 2023 in Spanish language, So I'm coming from a country, Japan. So Japan, just after this Meiji era in 19th century, I mean, in order to keep their independence, they, worked so hard that in 30 and 40 years, they beat even China and Russia at the time, So, and they developed a lot. And, on investment law, they wrote lots of books, So my question is, in that terms, in ISDS or in arbitration or other types of international economic law, what are the original contribution of the Latin America? For example, in case of China, if you see, for example, there's a Hague Academy of International Law in Hague, Netherlands. But there's also Beijing Academy of International Law in Beijing. So there's a decoupling, but still, as you mentioned about the decolonizing the knowledge. So the China and other Asian countries are trying to bring those centers or building those centers in order to give access to their own nationals, So they are trying to decolonize the knowledge at the time now. So in that perspective, what are the original contributions of Latin America?
Thank you very much. Do you want to ask a question now? Yeah. We should take you. You've been on the queue for a while.
It's a very, very conflicting word in literary studies and just a question, just developing on some of the things that have been asked. I think there is a practical application for the colonial theories, and there's been some practical areas in investment law even. I think the Ecuadorian posture under Correa, there was a fear after the constitution, fear, waiver from mining, or waiver from getting mining out of the investment system, and also the defense, even trained lawyers, typical arbitrators started incorporating concepts as the defense of nature, Pachamama, and Sumacuyacu, and everything around their defense. So I think there's some areas in which we can have practical examples. I was wondering if you could find any other, or if you think I'm wrong.
Thank you very much. And then almost calling from the university, to intervention. I'm very cautious. I'm very conscious about discourse about Pachamama and mother nature and nature rights. I would be very, very, very cautious if you want really to address it seriously, because basically Sumatra is not really something that it was bottom up. Like there are studies indicating this neo-colonial as well was defined by the foreign agents. I think that there is on one hand the need to incorporate that into the discourse about decolonizing international economic law, and there's some attempts with regard to sustainable development and more balanced investment law system. But on the other hand, we need to be very cautious, take everything with a pinch of salt, not to then again get into the terrain of neo-colonialism. And I think that, of course, I mean, now we are talking about these issues from a legal perspective, but when you go and you have a dialogue and the conversation with other disciplines like poetry and sociology, the rights of nature is not like something that is really clear about what we are talking about. There are so many readings, and I suppose that in a nutshell, yes, we need to look at this emerging narrative, but we need to be very cautious about incorporating them into the decolonization in the national community.
Thank you very much. Suresh?
Thank you. It's been fascinating. I'd like to pick up, I think, what was being said earlier on the Rosalind Higgins, subjects of international law. I think this is an area that what is a construct, really, and that construct was seen through typically what I would call, and I'm trying to avoid that term, but it has to be used, Western lens, yeah? And there is a series of waves, as I see it. So at one point, the MNC is coming in, and then you have the charter that was referred to, and then there's subjects of international law. Or should it be international economic law? Is there any difference to that? Yeah, because when you want to pierce them, do they have the capacity? And I think that really brings up many areas that wouldn't have been thought of before. This was in the 70s. And then you have now CSOs. And I think, like, if we bring up the debate or open up, why are we not including CSOs, that are really an important development actors in the light of Accra agenda and other actions that have been in place. So I think this is where there's a lot that could be said if you really want to take an expansive, with an A, not with an E, definition to say how things should move, that it should no longer be viewed through a narrow lens, but a new set of lens. And the typical yardsticks that you would use, like under Moderator Convention or whatever, should they be revisited because they were applicable to a certain age. And it's nothing's meant to be static, it's meant to be growing. What were the number of states at one point is so different now, and you have different players coming in, and I think that's what's important, to recognize the contribution of players, and in fact, if you really want to extend it even to significant communities at large.
Okay, so thank you very much for all those questions. Now, this is the challenge. We have 6 minutes, right? So I'd really encourage you if we can go to 2 minutes.
I'll be last because I like to talk a lot.
Okay, so it seems she's tossed the ball this way. Who wants to go first?
Well, I can go first.
Thank you.
I believe that there is a limit to the extent to which one can decolonize law, international economic law, because of the very imperialist colonial nature of law. So although we can use the language of rights, trying to incorporate new rights, nature rights, human rights, there will be a limit to the extent to which we can oppose that to the basics of Western legal thought. So once we have like the sovereignty, we have property, we have contracts, we have legal subjects, and there's a limit to the extent to which you can use the language of rights to go against this very foundational nature of law.
Thank you very much. Matheus, do you want to have some reflection?
Yes, I will only speak about one question, your question about human rights, because that is one of my main areas. I didn't mention it because I thought it was a bit outside the topic, but in fact, there is a strong relationship between human rights and international economic law. And when you introduce concepts like colonial accumulation of capital, and you understand that notion as involving both economy and violence, from this violence comes the long history of human rights violations in the colonial world. So I would say that the history of human rights runs parallel to the history of international economic law. They are together. Yes. We could write different histories of each discipline, but perhaps we could write also together these histories.
The original Latin American Charter of Human Rights is secret.
Yes.
So there has been regions different.
Yes, I have written that the developments in Latin America start in the 16th century. with Bartolomé Las Casas. Yes, from that time.
I mean, I think without being, privy to the histories of Latin American context, James and I have a friend who, when we hosted the African International Economic Law Network 2 years ago, initially, he's a human rights scholar. And so we invited him and he says, no, I don't do international economic law. And then we said, no, you actually do it, right? So the case for not living in silos, whether not thinking about the statutes, right?
What is his name?
Well made. Huh?
What is his name?
Well, I don't think I want to mention his name. You can guess who he is. He's a special rapporteur or something. So yeah, over to you.
Okay, I'll try to be short. So first, your question is very interesting because on the one hand, if you think about the Inter-American system, it was built in the context of the Organization of American States, which was basically promoted by the US for their agenda at the Marshall Plan, right? Like this idea, still this plan of America for the Americans, and the Americans is the North Americans, the US. And also you have the Organization of American States as a response to expansion of communism, right? And then you have the American Commission on Human Rights, basically Eurocentric, liberal, limited only to individual rights. What has happened here is that it's a bottom up. You have civil society, indigenous communities, taking those Western weapons to fight the powerful, right? So you have this thing. Now, why it doesn't happen in international economic law, or at least in investment law? Because there are no spaces for civil society. Like this is a state with company, and you could file amicus, but we heard that, we know that it's very difficult that a tribunal will accept amicus, and states will try to stop them because more documents means more time for the arbitrators, more cost. And remember that the average cost of arbitral tribunals in total $1.5 million, and usually the state has to pay for that, right? So I would say that. Now, this is very interesting, and again, I think is the coloniality of knowledge, right? The disciplines. We speak English, Spanish, French, right? This is the same happens in disciplines. Law is not Southern created. And then what we have is that what are the contributions of Latin America for ISDS? You will say, usually everyone here will answer, well, the Calvo doctrine, right? But who is Calvo? An Argentinian white man that lived in France, in Paris, wrote in French, right? Is it really what we have to do? So really don't see anything that we have to add there. But in terms of Black letter law of international investment law, what we can offer is resistance. That's what we can offer. And that's what we need to do here. And it has been seen from Latin America. We were the first countries to denounce ISDS at the exit. We are the ones planting different arguments. We are the ones, for instance, leading the Treaty on Business and Human Rights that at some point says human rights treaties should be superior to investment law treaties. And of course, all the international lawyers says, well, that's wrong, that's not possible, that's wrong. Anyway, so again, all that we can offer, I refrain from saying, yes, is the Calvo doctrine. I refrain from using that, I guess, is the resistance to struggle. That's what we can add there. And I will perhaps say, and Suresh, yeah, definitely what we need to do, and that's why it's very important, the work of both of them, is using new sets of lens to read our reality and still challenging the mainstream forum. And although they call us cute, crazy, yeah, mad, we need to still trying to push the research agenda and the policy powers further, and then try to revisit everything. And I conclude, for instance, our government is a leftist progressive government, but in terms of investment law, everything still very much the same. So left and right, they still love this ISDS system as it works. Thank you.
So thank you very much. And I think it's a very important point to sort of end, right? So where it brings me to is where I think at Dina yesterday, it was Jonathan Bonanza was saying too, when the new Nigerian president, gave his acceptance speech at his inauguration, it was clear he was wooing investors we'll make the rules flexible. The economy will be good for you. And so, and I've discussed this with change, right? And it's a reflection, no response. The idea is that all we can do is push back, right? Is resist. Is one I actually think that's not the only usefulness we bring to it. Because I don't really think there's a system, there's a vacuum that will be created while we're asking for that next thing, right? What are we replacing it with? Again, it's just a question, but I think it's where we get to and we ask ourselves very interesting questions. I can't thank the three of you enough for a very thoughtful, provocative set of presentations. To the questions from you all, if you live here and you get to Twitter world, and there's someone who has said there's no woman on this panel, please remember that both Isabel, Marcus, and many others have worked hard to ensure that this happened. I feel compelled to say this because before this panel, Isabel was expressing fears that one of our panels later today, one of the women participants dropped off, right? And so to see that come to life really puts the wrong view on the efforts of people who've tried to do this. We're all working hard to make sure the spaces are inclusive. I wish they were in the audience to see the people here, but I can't thank the three of you enough for making it enjoyable. Thank you very much.